Let's bring in our second guest this Lunar New Year. Talagang Lunar New Year. Former Supreme Court Senior Associate Justice Antonio Carpio. Sir, magandang hapon and thank you for joining us.
Good afternoon, sir.
Good afternoon. Good afternoon to our viewers.
Yes, sir. Sir, let me start off with this. The debate, the proposed debate. Is there any update there? And then from there we can go to treason and then to other issues like effective occupation.
Well,
debate first.
Yeah, he said he accepts the debate pero binago na yung topic, no? So, I think we have to go back to why we're having this issue. Sabi niya, there is no such thing as a West Philippine Sea. So yun na lang dapat pag-usapan namin. Is there such a thing as a West Philippine Sea? Secondly, sabi niya, we have 4 islands in the KIG that are outside the exclusive economic zone. We cannot claim them. So the issue should be, can we claim islands of the Kalanayan group outside the EEZ? Yun na lang, simple na lang. Kasi iba-iba yung gusto niya, iba yung sa akin. So let's just focus on why are we having this debate, or this discussion? No?
Oh, sorry,
Justice,
sir.
I think we lost your line a little bit there.
Yeah. Yun. So I think we have to go back to the basic why we have this discussion. Ang sabi niya, there is no such thing as a West Philippine Sea. So I take the position that we have a West Philippine Sea. It exists. Tapos second, sabi niya, may 4 tayo na isla sa KIG na outside our EEZ. Because of that, because they're outside, we cannot claim. So simple lang. Can we claim islands of the KIG outside our EEZ?
Yes, sir.
So para simple lang, no? Para yun ang maintindihan ng mga all the people.
Sir, you're okay with that?
Yeah.
You're okay with that?
With those two.
I think that was
With those two. Kasi nagiging I propose, he proposed, so let's go back to
the basics.
lumalayo Kasi katulad sabi niya na he will charge me with treason. Sabi ko wala namang treason sa batas during peacetime. Sabi niya, hindi ko na ikaw i-charge ng treason. I pronounce you guilty of treason. He wants to be the complainant, judge, the complainant, prosecutor, and judge rolled into one. So how can you have a intelligent debate with somebody like this? No. So we have to have certain basic rules. Ano bang pinag-uusapan natin?
Sir, just a little bit of context. Did you know Senator Marcoleta before, or have you two met, or you don't know each other at all?
No, I know he was a party list member of the House for a long time, but I haven't personally met him.
Sir, so those 2 points do sound workable kasi I suppose that's easy for people to understand. First, kung meron talaga West Philippine Sea. Pangalawa, is it possible for a country to claim a structure claim something
territorial sea
outside of your EEZ, which I think is also pretty easy rin to answer. But sir, can you elaborate on the second one? Yung being outside the EEZ, what are yes, sir.
Sabi niya, why are we claiming islands outside of their EEZ? There are 4 islands.
Like Pagasa.
So let's debate. Can a country claim islands outside of its EEZ? Kasi that will be the issue, no?
Yes, sir. Sir, you mentioned kasi I got correspondence from you through Mike Santillan. Kasi there have been some people who have been arguing, for example, J. Batong Bakal, that effective occupation, at least in our case, is already effective, and therefore we can clearly claim to Pagasa Island. But you also mentioned as well the Clipperton case and the Eastern Greenland case, 1931 and 1933. Could you explain that a bit?
Yeah, well, the first case is the Islas Palmas, 1928. The issue there was who has sovereignty over Islas Palmas. Spain although this was case arose during the American regime, whether Spain by mere discovery of Islas Palmas acquired sovereignty, or whether it was the Dutch in Indonesia who had a treaty with the locals. 700 people lived in Islas Palmas at the time, who pledged allegiance to the Netherlands, recognized the Netherlands as their sovereign. So the ruling was the discovery alone is not sufficient to acquire sovereignty. You must exercise peaceful and continuous display of sovereignty. And it was the Dutch that Pero Islas Palmas is a inhabited area. There were about 700 people. And the arbiter said, I am deciding this case this way because Islas Palmas is inhabited. This is different from an uninhabited island. But he did not explain that. Now, the next case is Clipperton Island, 1931. And in that case, Clipperton Island is totally uninhabited, uninhabitable. So it was first claimed by France, and about 19 years later, Mexico claimed it, so they submitted it to arbitration. And the ruling was, if it is uninhabited, and you are the first country to claim it, there are no other claimants, your title becomes complete right away. Because you cannot go to the island and then ask the turtles and crabs to sign a Pledge of Allegiance. So, ganyan din nangyari sa Eastern Greenland. In the 1700s, Denmark claimed the entire Greenland, pero napakalamig doon sa eastern part. They did not colonize the eastern part. They colonized the warmer areas, the western part. Later on, Norway claimed the eastern part. So they agreed to submit it to arbitration. Sabi ng court, when Denmark claimed it in the 1700s, they populated only the warmer areas. They were not required to colonize the uninhabitable places, the very cold places where humans cannot live, because the law will not require you to do the impossible. Therefore, even if they did not actually colonize those parts, they still acquired sovereignty. So that is the ruling now. Yung Islas Palmas applies to a case where the island is inhabited. You have to show continuous and peaceful display of sovereignty. Discovery is not sufficient. But if the island is uninhabited or uninhabitable, like Scarbor Shoal and the Spratlys, you acquire title right away upon discovery and proclaiming that is yours. So sa atin, 1734, Spain claimed the Scarbor Shoal and the Spratlys in the 1734 Pedro Murillo Velarde map. So Spain acquired sovereignty as of 1734 dahil nobody lived in the Spratlys at the time. And also Scarborough Shoal. You cannot live in Scarborough Shoal. There's not a single blade of grass there. And even the arbitral award of 2016, the tribunal said the Spratlys, none of the islands in the Spratlys can be inhabited because there is no water there. If there is rain, there is a little water in the aquifer, but after 3 months, the water is gone. You cannot live you cannot survive there based on the resources of the island alone. So, what applies to us are the rulings in Clipperton Island and Greenland. Because Scarborough Shoal and the Spratlys are uninhabitable. Were never inhabited in 1734 when you claimed it, when Spain claimed it, in 1808 when Spain reiterated its claim, in 1875 when Spain again reiterated its claim.
So, sir,
So
it is
yung
not...
Islas Palmas does not apply to us as far as Scarborough Shoal and the Spratlys are concerned.
So, sir, it is not effective occupation which is the basis for our occupying
Wala. Kasi
Cagayan Island.
effective
Papagas
occupation, pag may tao doon who will recognize you. Eh yung mga turtles and crab who will not even sign a Pledge of Allegiance.
Justice, coming back to the treason charge, I believe it originated with the when Senator Marcoleta brought up yung Magalona versus Ermita case that he said that you had penned in 2011, which upholds the constitutionality of RA 9522, and he says that because of that we gave up 242,000 square nautical miles of the country's internal waters. Could I have your reaction to that, please?
Yeah, that assumes we had those waters as our territorial sea. That's just an invention. We never had those waters under international law. Because under international law, you are entitled only to 12 nautical miles from your coastline or from your archipelagic baselines if you are an archipelago. So, hanggang doon lang. And if you look at the Treaty of Paris, it says there, Spain cedes to the U.S. the Philippine archipelago comprehending the islands, consisting of the islands within the treaty lines. What was conveyed by Spain were islands, not everything within the 1898 Treaty of Paris lines. And that's why, until we enacted Republic Act 9522 to clarify, the U.S. always protests. They have protests before submitted to the UN that we are claiming waters beyond our territorial sea, 12 nautical mile territorial sea. We do not have, those are not our territorial sea, beyond 12 nautical miles. So, the party to the Treaty of Paris, the one who received the archipelago of the Philippines, said we never acquired those islands, those waters beyond what was recognized then as the territorial sea. At that time, 3 nautical miles lang ang territorial sea. In 1982, under UNCLOS, it was extended to 12. So, how can you say we lost something that we never gained, we never earned, we never owned?
Yeah.
Because the international law never recognized a territorial sea beyond 12 nautical miles. So, yung sinasabi nila, yung assumption nila na atin yun, no. Even the party to the treaty said, no, we never acquired beyond the territorial sea. Ang gusto nila, everything within the Treaty of Paris lines will be our territory. Kasama na doon yung high seas Portions of that are high seas already, and a large chunk of that are EEZ. EEZ, Exclusive Economic Zone, is not territory. That we don't have sovereignty over EEZ, sovereign rights lang. So yung basic assumption nila na, we will lose thousands of square kilometers, we never owned it. It was never recognized it's not recognized under international law. Even the US said we did not acquire those beyond the territorial sea. Palagi nila reiterate yan.
So, Magalona versus Ermita did not reduce our national territory.
Yeah, of course, because it was overwhelmingly approved by the House. The Republic Act 95 overwhelmingly approved by the Senate. Unanimously approved by the Supreme Court. So,
Justice.
yung sinasabi nila, we lost something, we never owned it. No country in the world ever recognized beyond 12 nautical miles. And in our Constitution, nakalagay, we adopt the general principles of international as part of the law of the land. 12 nautical mile territorial sea is general principle of international law. That is the maximum territorial sea you can claim. So, yung sinasabi nila na everything within the 1898 Treaty of Paris lines, the waters around the islands are our territorial sea. That violates customary international law, that violates UNCLOS, and no country will ever recognize that. Parang 9 line yan No country will recognize, except of course China.
Justice, mag-shift lang ako kasi we started this session doon sa, I saw you listening kanina when we were talking to Ping Lacson. Tatanungin ko lang kayo your views on the arrest, the possible arrest of 2 senators for crimes for which they are facing charges in the International Criminal Court. Ano bang process doon?
Well,
Kasi
we
sabi
have-
nila, it should not be like the one that was followed dun kay President Duterte.
Well, what was followed during the time of President Duterte, when President Duterte was shipped or was brought to the Hague,
Yes.
they followed, they implemented the provision of the humanitarian law on international humanitarian law in the Philippines.
9851.
That the government has the option
Yes.
to surrender a person accused of a violation of human rights or genocide or crimes against humanity to the international tribunal or prosecute that person here. So yun ang ginamit nila, may option. That is in the law. So, the Supreme Court will have to decide, no? Whether that still requires that the executive branch who will implement that provision must go to a local court to get a warrant of arrest. That is still an outstanding issue. It could go either way, but until that is declared unconstitutional,
Yes.
it will be followed by the executive branch. So the executive branch can implement that up to now because it has not been declared unconstitutional.
So, sir,
Oh.
until the Supreme Court
Oh.
says na you cannot do this, they can arrest.
Yeah, because that is in the law. That's presumed to be constitutional. There's a presumption of constitutionality.
Sir, next question
So
would
the
be,
law allows it actually. Yung ginawa
Yeah.
kay President Duterte, the law that was passed in 2009 pa yun, allows it.
Yes, there is that provision. The government authorities have the option to surrender the accused to an international tribunal or prosecute him here in the Philippines.
Saka walang requirement to go to a local court.
There's none. It's silent.
Wala.
sir, next question would be, while Congress is in session, can he be
Kailan ba yung
arrested while it is in session, especially considering na, I know there's a 6-year dapat na if it's below 6 years, you cannot be arrested while in session.
Yeah.
But also the question
Anong
raised
definition of
by
session?
Ping Lacson was we don't know how much the penalty would be sa ICC for co-conspirators. So that's also a big question mark.
Co-perpetrators.
Co-perpetrators. So what's your view on that, sir? Can he be arrested while in session? Can they be arrested actually?
Saka ano yung session? Ano yung session?
And ano yung session?
Oo.
Well, my calendar yung Congress, no? At
Yeah.
3 years kasi yung Congress. Every year they have a calendar,
Yes, sir.
session calendar, from July to June. For one, June, they adjourned sine die. That means
Yes.
they adjourned without a date for resuming session.
Yes.
Sine die yun. Well, if you want to be liberal about that, session that you have to wait for the sine die adjournment, no?
Which is June.
That's one interpretation. But the Congress, during that period from July to June, in one calendar session, they also adjourned from day to day.
Yes, sir.
Oo nga.
So, the other interpretation, if we adjourn on that day, then pwede na arrestuhin. It's no longer in session, no?
Actually, sir,
Yeah.
they use the word session is suspended for the day-to-day uyan.
Well, just like in the impeachment case, sabi ng Supreme Court, session day means calendar day where there are sessions.
There's a session.
Yeah. Oo nga.
Pero ang sabi ng Supreme Court, this applies only to impeachment. So, hindi mag-a-apply ito sa arrest.
So, sir, anong tingin nyo? Which one is
The fact that they
more
changed the
applicable?
definition of session
Oo
days.
nga eh.
Well, I take the view that if it is adjourned for the day,
Pwede
wala na. Pwede na maaresto. Pag umuwi ka na sa bahay, pwede ka na arestuin.
Yeah.
When you are actually in session in the Senate Hall or in the House of Representative Hall, yun ang session. But if you go home, huli ka.
Kaya nga.
Just
Paano po yung 6-year cut-off, 6-year imprisonment cut-off? Kasi sabi ni
Yung-
Ping Lacson, we don't know how long the penalty would be with the ICC if you're a co-perpetrator. Is that the word for it?
Well, I think
But,
you can check that. Nakalagay naman doon yung yung
Penalty.
range of the penalties
But Justice Carpio, yung
Meron sila.
I don't know how much of the interview with Senator Lacson you heard, but the idea that the ICC arrest warrant has to go through a domestic court keeps popping up. But earlier, I think I caught you say that the law is silent on it. So I'm wondering, where are they getting this idea that there is a
Need
provision?
for a local court.
There is a provision that says it has to go through a domestic
because
court.
there is a provision in the Bill of Rights,
Bill of
in the
Rights,
Constitution, that only a judge can issue a warrant of arrest. Only a judge. Now, ang sabi ng iba, but the ICC warrant of arrest was issued by the judges.
Yeah.
That should be sufficient. But ang iba, sabi nila, only a judge can issue a warrant of arrest. The judge there in the Constitution means a local judge.
Wala naman nakalagay doon.
Yeah, that's why I'm saying we have to submit this. This will reach the Supreme Court, and I really don't know how the Supreme Court will rule on this now.
So it doesn't actually specifically say it has to be a domestic judge, a local judge, basta
Yeah,
judge.
Wala.
but the Constitution, the text doesn't say local judge. Only a judge can issue a warrant of arrest.
But
But
until or
until the
unless...
Supreme Court issues a ruling,
Or
the
TRO.
executive can do what it wants.
Yeah, because it can
Yeah.
interpret the law
Yeah.
the way it sees it because it's reasonable naman. Wala naman nakalagay you need a warrant of arrest. No?
Yes. Kasi ini-invoke ng Malacanang yan yung option na yan, sabi ni Claire Castro
Yeah.
We have
Yeah.
the option to surrender. They actually mentioned it already.
Yeah, actually, it was questioned by the
Yeah.
Duterte family. I think also Bato questioned it. But it became academic kasi nakaalis na So they did not rule on it anymore.
Kaya uulitin nga daw ng Malacanang. Yan ang sinabi nila. That they will follow it in the case of the two senators and the others. Kung sakali.
Because that is the provision of the law has not been declared unconstitutional, that the
Yeah.
government authorities has the option to surrender or to prosecute.
Sir, kasi yung kay Duterte dati, nailabas kagad, so naging moot and academic. In the case of Bato, if they arrest him and it takes him some time here before he's transferred abroad, and then that is the time for them to seek judicial intercession. Tama ho ba? Pero kung gawing santong paspasan, kagaya kay Duterte, then it also becomes moot?
Walang habol.
Yeah, that's why Bato filed a case to test it, no? Pero sabi ng court, wala namang warrant of arrest sa iyo
Wala pang
So
basis.
wala pang justiciable controversy.
So you cannot then preempt the issue
Yeah.
by filing
Pero
that.
dapat handa siya if he really wants to question it, no? Handa na siya. Pag what he can do is surrender now and then with the file niya kagad at the same time, no? Kasi pag nahuli yan,
Tapos nilipad
let's say
kagad.
in the province, baka diretso na siya ilipad, no?
Oo.
And then it becomes
Unless there's a
Duterte.
TRO, no? He will need a TRO.
Ha?
Diba? Kung walang TRO, pwede siyang ilipad ng
Yes,
gobyerno.
so what he can do is surrender now with the understanding or handa na yung petition niya kagad, no?
Pero sir,
Pero wala pang justiciable cause. Wala
can
pang
you surrender
restaurant.
kung wala
Hindi,
pang...
kasi ang assumption natin, nandiyan na yung warrant of arrest, hindi lang nila in-announce until they actually arrest.
Aha. Pero yung
Kaya
nga, sir,
nagtatago na siya ngayon because he believes there is already a warrant of arrest, pero hindi lang ina-announce until he is arrested.
Pero yun nga sir, can he therefore file a case again to stop or to restrain his arrest kung wala pa namang nilalabas
Wala pa
ang gobyerno.
Yeah,
wala.
what he
or
can do is
Interpol.
go to the Senate and then
Yeah.
file the
Wait for
case
an
immediately.
enforcer,
At least nasa Senado, nagsisession, hindi siya arestuin, no?
Okay.
Oo.
binigyan ni Justice Carpio ng tips.
Hindi,
he
para
can-
bumalik na dun sa Senado.
Para bumalik na at saka bumoto na.
Pero sir, teka, but if we go by by Article 6 Section 11, yun nga di ba? Your immunity is only good if it's in session and your case is not punishable by more than 6 years. So the second the second proviso will also kick in.
Yeah, but I don't know the range, no, of the kung co-perpetrator lang. Pero I think pasok yan eh. It will be more than 6 years eh. So delikado rin siya.
Kasi I think under RA 9851, it's 12 years for crimes against humanity. But then again, I don't know if this is for principals or co-perpetrators. Okay.
Hindi pa naman natin alam kung principal yung co-perpetrator or
yeah.
accomplice lang eh. We don't even know. Oo.
It was
Kasi
just
pag
a-
binasa mo yung charge sheet, mukhang ano siya eh, mukhang principal eh.
Yeah, because he signed the Operation Tokhang Manual, eh,
Yeah.
yung circular.
Yeah.
Yeah,
Yeah, he was
Chief implementer ang
the first
accusation sa kanya.
implementor
yeah.
because he was the chief PNP when it was first implemented. And siya nakapirma doon. He issued the
Chief
circular.
implementer siya, architect.
Yeah.
Okay. We've run out of time today, but thanks so much for talking to us and explaining all of that. Former Supreme Court Senior Associate Justice Antonio Carpio.
Thank you, sir.
Thank you
Thank
also.
you, Justice. Happy New Year, Justice.
Happy New Year.
yeah.
Kung
Happy
hey
New
patsoy.
Year.